Whenever people look at the events in Ukraine and the scope of the prosecutor's investigation, the first thing I point out is that the crime of aggression, of aggressive war, is by, as the prosecutor himself has stated, is beyond his remit. And that is because neither Ukraine nor Russia are members or signatories to the Rome Statute. The prosecutor acquired jurisdiction over Ukraine solely by virtue of what we call the ad hoc submission, a referral, an ad hoc submission by a non-state party saying that for this particular situation, we are asking the court to step in. So that removes what otherwise is the most obvious crime that should be investigated, which is aggressive war. That leaves us with the other crimes, that is war crimes, crimes against humanity, and genocide. And we move fast forward. The Office of the Prosecutor of the ICC has issued a warrant of arrest against Putin and the head of his department, of one of his departments. And the crime is the forcible transfer of children from Ukraine to Russia. And apparently, and once they are in Russia, they are educated in the culture and language of their new location. And that is a war crime under the Rome Statute. Now, the larger debate is the prosecutor actually could have charged many other crimes. There's nothing to stop him from doing that now. The investigation is still ongoing. There is already one warrant of arrest for the forcible transfer of the children. Nothing to stop him from investigating other war crimes, crimes against humanity. But my first reaction was, well, why this crime and not others? In fact, if you look at the facts giving rise to the warrant of arrest and forcible transfer of children, forcible transfer is actually identified as one way of committing genocide. And in fact, it fits the profile, because if the heart of the crime of genocide is to erase a group by erasing them not just physically but erasing their identity, then it is specified in the enumeration of genocidal acts that this act of transferring the children is a form of committing genocide. So, one wonders why the more specific crime of forcible transfer was charged rather than I would say, the larger crime of genocide. It can still happen. Perhaps they are collecting more evidence, although I feel that if they had enough evidence for forcible transfer, they should have enough evidence for genocide. It might be part of the prosecutorial strategy to have a specific crime charged, to issue a warrant of arrest on that immediately, and sort of it buys them more time to investigate other crimes in the meantime, because anyway the warrant of arrest is already in place. But going back to identity, that is a crime which goes into how important it is for these children to have their original nationalities recorded and held by them. Otherwise, that is how genocide is committed. Their original identities are slowly erased. Children are very vulnerable. They lose their facility with the language. They are disconnected from the original culture. And that goes into the heart of why genocide is punished and prohibited. The crimes are defined in the Rome Statute, and then the elements of crimes are a separate document. And for the crime for which the warrant of arrest was issued. That is the crime of forcible transfer. It is necessary that the element of a nexus to an armed conflict be established. And of course, there is an ongoing armed conflict here. And the victim must have protected status, that is, in this case, a civilian. And the perpetrator must be aware of the protected status of the victim, and of course the actual forcible transfer. Now, looking at the larger picture, had they charged for exactly the same facts the crime of genocide, they would have had to prove that the children who were transferred were below the age of 18. And they would have had to prove the genocidal intent. That is the intent to eliminate in whole or in part a group identified along national, ethnic, racial, or religious lines. And you are correct. These are the elements that will have to be proved by the prosecutor with competent evidence in the course of the trial. You asked about how the evidence will be gathered. What I saw in the ICC is that the prosecutor, the office of the prosecutor, has a whole team of lawyers and investigators who go to the field, gather the facts and the evidence. So at this stage, where the prosecutor has already commenced the investigation, I imagine they already have their teams in place to gather evidence from the witnesses in the field. That is in contrast to the earlier stage of what is called a preliminary examination, where they are usually limited to open source material. But that stage was rendered unnecessary because there was a direct state referral to the prosecutor. And the state referral came from some 37, 39 states acting in solidarity. And that hastened the process immensely. In fact, the quick and robust response in the international community to the events in Ukraine has been a matter of public comment already. Whether it was from the International Court of Justice responding with provisional measures, or the ICC responding with the direct initiation of the investigation, or for that matter, the UN General Assembly adopting a resolution calling for action, in effect going around the paralysis of the UN Security Council. I think all these responses have been most impressive. And it also goes to show the extent of the consensus on the questions at stake here.